consist of civil rights leaders, community activists, academicians, and attorneys whose fundamental objectives focus on reforms in the criminal justice system, particularly in the Cleveland Division of Police. The goals of these organizations is to make the Cleveland Division of Police a model department that can operate without bias of any sort, avoid the use of excessive or unconstitutional force in the discharge of their duties, and perform their duties consistent with the Ohio and United States Constitutions. These organizations individually and collectively have reached out to various stakeholders in the Cleveland community and developed relationships with numerous individuals who are directly impacted by police activity. They have solicited concrete input from community stakeholders as to appropriate police reforms, studied police reform efforts in numerous other cities, and provided recommendations to both the City of Cleveland and the Department of Justice. During the investigation of the Cleveland Division of Police by the United States Department of Justice. The party settlement agreement specifically recognized the importance of community input into the way police services are delivered, and that ongoing community input into the development of reforms, the establishment of police priorities, and mechanisms to promote community confidence would strengthen the Cleveland Department of Police and the police-community relationships that is necessary to promote public safety. The NAACP, the Collaborative, and the National Lawyers Guild support that proposition, since all parties recognize that the consent decree, under the best circumstances, will have a limited lifespan. Based on the totality of these circumstances, the NAACP, the Collaborative, and the Guild have made suggestions to the court that the following recommendations be considered. Number one, the office of Inspector General should be completely independent and not report to the police chief, whose policies he or she would be obligated to critique. Number two, the Division of Police should not be permitted to police themselves regarding the most serious use of force policies that result in homicides or serious bodily harm. Number three, to ensure bias-free policing, the collection of critical demographic data, including race and gender, is essential. Number four, specific provisions for addressing youth or young people is absolutely necessary. Number five, to be truly effective, the Community Policing Commission should be strengthened in a number of significant ways. And number six, last but not least, bestowing on the monitor blanket testimonial immunity is not in the best interest of the community. You have before you a number of people that either represent the NAACP, the National Lawyers Guild, or the Collaborative for a Safe and Fair and Just Cleveland. These are the proposals that we have submitted to the court. We're optimistic that the court will seriously consider them and take appropriate steps to make sure that this becomes a part of the Cleveland Division of Police. We have with us Subodh Chandra, Terry Gilbert, Marvin Brown, Ed Little, Jack Worthy, Julia Shearson, and a host of other people that have come out to support what we're trying to accomplish. So at this point in time, we would entertain questions from the media relative to what we are trying to accomplish.
What kind of precedent is there for getting a police consent decree modified after it's been agreed to by the parties?
Any court order is modifiable. Therefore, we take the position that, though this is a good document, it can be made much better. And the recommendations and suggestions that we have put to the court hopefully will make this a model for all other consent decrees throughout the nation. Subodh?
And this particular consent decree expressly provides that it can be modified.
But has that happened in other cities that you know of?
Julia, you want to address that?
Well, I would say, for example, with respect to the community Police Commission. It has been modified. One of the things we're asking for is changes with respect to the deadlines for which the Community Police Commission will have to review the use of force policies, the bias-free policing policies, the search and seizure policies. As it stands, they only have 2 weeks to do that. So in 2 weeks, really, all you could do is a rubber stamp. So in Seattle, for example, deadlines were extended, and there were some changes put forward by the court. In Portland, for example, and many other cities, I think what's happened really is a step has been skipped. And what that step was that courts in other jurisdictions have actually invited interveners and interested parties to come forward, and they have held fairness hearings on the consent decree before the order was signed. So we have concerns that that step was skipped here in the community, and that opportunity was missed to get some final tweakings that would have improved the decree.